I'm gonna share the old screen here. Everybody can see this, I hope. So what we're talking about today for the next hour or so is negging against court Affs. We're all about negging against the court affirmatives. And to first answer this question, we got to answer the question, what exactly do we mean by court affirmative? And court affirmatives have kind of three main parts that shape what you have to do is when you're neg, and it's topic advantages. Topic advantages means they're going to reform something about the criminal justice system. It's going to be a fairly typical advantage. The solvency is going to be a little bit different probably because they're going to talk about litigation and enforcing things in court and precedents and things of that nature. But letting people out of jail, changing the way policing works, things of that nature are all going to be the same. So it's going to be fairly similar. And then what makes it a court advantage, is the second element. Could be included in the plan, probably will be involved in at least one of the advantages, which is precedent or grounds advantages. And that means the advantage is based off changing the way the court interprets things in areas that are unrelated to criminal justice reform, generally generating impacts based off that. And then the third thing, I think there's a third thing, yep. The third element that is involved in these debates, court link uniqueness. And that, what I mean by that is the affirmative team will bring up a lot of court cases that may not be very similar to the F, but may characterize the negatives link arguments. And then definitely they will try to bring up pending cases or past cases that were criminal justice specific or things of that nature so that they can compromise negative disads. And, every F can bring up link uniqueness, but court Affs are fairly typical, mainly just because the courts make rulings every year. So there's a cycle of which, it's not like court action. It's not like the court takes any years off. The court is always acting. So the neg has to figure out how to respond to this. And I guess I'll say here at the top that it's interesting that people choose court affirmatives to read, mainly because I think what happens is people tend to pick them because they kind of are easy. If you research like law reviews, the law reviews generally have reforms or advocacies as part of it, and they just say they propose court action. So it kind of falls off the page in that sense. And people are always kind of think that these precedent or ground advantages, I wouldn't say that they're unique to court Affs. You could write those for other agents. You could write those for the executive or Congress per se about changing the way that agent interacts with that area. But court advantages makes it just so simple. Again, I think a lot of people get attracted to court Affs because it's so easy. It's like low-hanging fruit, not necessarily because it's the most strategic thing you could be doing. And there also might be an element of this. There's always conversations in the second semester, which is like, oh, there haven't been that many court Affs. Maybe we should read one. There's an assumption that the negative is going to be less practice or less aware, or maybe they forgot some of the key elements that they need to do. So hopefully this elective means that you will be prepared. On this topic, I could see, well, we're going to get into it, but court Affs could be more ubiquitous, like similarly on immigration or education. So this might be skills that you might just need for the entire semester. Oop, I had one more. The plan is announced in June. This is just a procedural sort of argument that we'll talk about a little bit later. But this is just a classic that, you just need to write one block for and know how to deal with it. But generally the court, hears cases in like the fall. And I think they might hear oral arguments in the spring, winter time too. I'm not sure. Maybe they just do it in the fall. Maybe they just do it in like October and maybe November. And then they announce them starting in, maybe late May, but definitely a lot in June. COVID made it so Supreme Court season was like in July this year. All right. So here's the big key to answering court Affs. The issue is that they are disjointed. And what I mean by that is that the mechanism and the precedent advantage don't have very much to do with the topic area, the topic related reforms. So you have this thing that is not intrinsic to dealing with criminal justice. And The key to exploit that is you just test both parts of the Aff at the same time and see which one they mess up more. And what I mean by that is we are going to discuss, we're going to talk about a series of counterplan and disad strategies that test them both at the same time. And then if you present them both like this at the same time, then you will generally be in positive time because they can't really make an answer that answers both at the same time. And you'll have fully covered your bases. The other issue is because few strategies clash with the entire court F at once. That's kind of hard to put together. But there is one, and we're going to start with it. So the first thing you need in your NIG court arsenal is the amendment counterplan. And this is the idea that, we should pass a constitutional amendment to do the court F. And like the main reason why this is attractive is because there is a series of examples where the Supreme Court made a decision and then the use of constitutional amendment was used to overturn it. So particularly if the AF wants to change precedent or says a particular past court ruling is problematic, the constitutional amendment is very suited for that kind of affirmative. And there's the 4 examples that are mentioned in most every card. The 11th Amendment was based off Chisholm versus Georgia, 14th was based off Dred Scott, 16th was based off the income tax being overturned in Pollock versus Farmers. And then a federal law was passed to make the voting age 18. It was invalidated, then passed by a constitutional amendment. That was one of the most contemporary amendments. And the issue is that you can find evidence. There's always, you would think you have to be willing to read cards from like the 70s and 80s, but there's always cards about constitutional amendments and criminal justice. And recall that you feel free to just answer questions. You can kind of just pipe up. I don't need to recognize you or anything. I can't really see everybody in this shared screen view, so you can just ask a question if it occurs to you, and I can slow down. But that's an article free of charge. I think it's from like 1977, but it just makes it just an example that there is solvency advocates for constitutional amendments and criminal justice. So let's talk about a little bit what the AF would say against such a counterplan. And the big one that they like to talk about is judicial circumvention. And this argument means that the court is going to interpret the amendment in like a stupid way. They're going to do what they want to do. They're going to water it down. They're going to make it mean something it doesn't mean, because courts can just kind of manipulate the meanings of text and things of that nature. So the amendment isn't really going to work the way it's supposed to work. And so there's 3 answers that you can make to that. You can definitely say fiat or it links to them. And this argument means that if it's the case that the court wants to decide in a certain way, like if the Roberts courts and the conservatives don't want to be nice to criminals or whatever, then it is not the case, or any part of the judiciary, the lower courts or whatever, then either that motivation still applies to the AF. The AF is making them do something they don't want to do. There's plenty of ways to circumvent. There's plenty of other courts binding precedent. Precedents do not enforce themselves. They are not on face, like you get eviscerated or whatever if you don't do the precedent. People have to buy in, people have to follow it along. So there's plenty of room for circumvention, even in the case of judicial decisions. And the other good argument is audience costs. This is the idea that if the entire country, and I think in most constitutional amendment texts, it's like the 50 states do the Article 5 process. If they were to pass an amendment and so all the states pass an amendment and the judiciary says like, fuck you, like we're not going to do this, that the judiciary is not going to go out on a limb that much. Like I said, they base their ability to do things off legitimacy, off public support. Other people have to enforce their rulings. So if the entire country is going one way, the judiciary is not going to buck that trend, basically. And then it's also empirically denied. You can ask this on cross-ex, you can talk about it. It's just like, it's an empirically denied. There is this idea that the courts, well, the big thing is that the amendments as passed in the US jurisprudence as constructed is not very egalitarian. It's not very progressive. So the Supreme Court, I would say, is faithfully executing those amendments. It's just that the problem is those amendments are not very good in the first place. So I would say it's empirically denied. There's not really an example of the court just totally bucking an amendment, particularly in the case of like ones where it got directly overruled. The other big generic argument is delay. First thing you can say is that they don't have any time-sensitive advantages. It's kind of a classic tactic for delay. There's nothing unique about amendments versus court, although the court generally is slow, and the precedent causing kind of bigger structural change is a kind of slow process. And then another classic fiat solves. This is kind of just counterplanning 101, where you just want to say there's no impact to the deficit. It links to them. Fiat can resolve it. Amendments obviously can't happen fast. I tried to dig up exactly. There wasn't really good little snippets about like how quick a convention or amendment could pass. That was kind of somewhat contemporary for like, post-Civil War additions to, although the Reconstruction amendments did kind of pass pretty quick. They passed within, pretty quick after the Civil War ended and whatnot. But same thing for court decisions. Court decisions can usually take forever. They can percolate forever from the original case being heard to maybe like the Supreme Court making a precedent. And so I think that equally links to both of them. And then they might try to say that judicial review is key. The judiciary needs to be involved in the process in some way. And because, the constitutional amendment is kind of like an agent counterplan. So they might just say, they might try to come up with a reason why judicial review is key, particularly for judicial independence. Like the court has to go out in front of people and make their own rules to demonstrate that they're independent. That's kind of the classic one. And again, it kind of depends. Judicial review, generally, the counterplan can solve that because you can kind of set a new precedent that the courts can enforce the amendment. The courts can have a role in interpreting the amendment. So there can be judicial review based off what the amendment authorizes. And then the other part that's tricky is for this to be a real internal link, the actual for judicial review, because a lot of people's advantages are just about, you got to get rid of some bad criminal justice policy. The constitutional amendment can do that part if it just says it's unconstitutional to do certain criminal justice practices. And then the other part is you got to get the courts to think about certain precedents a different way. And to make that really judicial key, you would have to have arguments about why the judiciary has a unique institutional role in making other actors deal with precedent in the right way, right? If it's just a question of everyone just needs this idea of good precedent just needs to become front and center and everyone just needs to get on board with it, that doesn't necessarily provide a who does it, right? Like the judiciary could raise the consciousness of that precedent, Congress could, the president could, obviously a constitutional amendment could, since that's kind of like the biggest government change that that's available under the Constitution. So you got to scrutinize the specifics of their precedent advantage, but generally speaking, their internal link is not going to be that nuanced or specific to make it so it's a real solvency deficit to amendments. And those are the kind of big three solvency deficits that people try to make to that counterplan. And that counterplan is useful because it tries to do the entire act. It does the criminal justice part and changes the way the court interprets certain things. There's net benefits to this counterplan. And this is our segue into talking about court disadvantages. You might have heard of a court, I don't know it. I never know what's going to happen on these slides. It's a mystery to me as much as it is to you. But any court DA is a net benefit to these, obviously, because it doesn't use any court actors, and the courts don't have to go out on, they don't have to take the lead or anything. So any court dissent works. We're going to talk about court dissent now? Nope. Still going to talk about other stuff. So when I was talking about testing both parts of the affirmative, that means that one set of strategies is going to say that reforming criminal justice is good, but having the courts act is bad, and then vice versa. Having the courts act is good, but reforming criminal justice is bad. So we're going to talk about the first example, courts bad, topic good. The key part here, and this is separate from constitutional amendment. Constitutional amendment is kind of like for like normal Affs, the state's counterplan is to normal Affs, the constitutional amendment counterplan is to courts Affs. This is different. This is when you use Congress to solve what's wrong with the criminal justice system. You use Congress specifically. Generally, the thing you got to do to make this the next level strategy, again, to preempt like judicial review key arguments and precedent style arguments, is it's good to specify some sort of enforcement or accountability that can mirror the process, some auditing, some remedies that are non-judicial, and things of that nature, to mirror the process of judicial review, to ensure that the counterplan is like more durable and you can like change the way it works, similar to the way litigation evolves, the way people understand precedents and things of that nature. All right, now we're going to talk about court disads. Most of you may, if you debated court Affs, you might have heard about the legitimacy disad. This is the idea that courts have a certain amount of legitimacy and certain decisions can impact their legitimacy both positively and negatively. And this disad can go either way. It could say legitimacy is bad or legitimacy is good. And that's why most people write it, because you can take what the Aff is. If the Aff is very liberal and popular with the public, you can say it boosts the court's legitimacy and then say court legitimacy is bad. Or if the case is controversial or kind of a weird thing for the court to do, you can say that would negatively impact the legitimacy. Or if it's like out of step with precedent or it's nothing they've ever done before, then you can say the legitimacy is good. But the issue with this kind of argument is that it's tough to figure out what the threshold for an impact is, particularly in light of link uniqueness issues. Because like we said at the top, the Aff is going to bring up a lot of court cases. The courts do a lot of stuff. And legitimacy is kind of speaking to the overall reservoir of how the public thinks about the courts with all their decisions in mind. And so, you know, if the court is making very particular rulings or very specific subset rulings of criminal justice, similar to how small Affs are harder to link to politics, it might be hard to distinguish the small court Aff from all these marquee decisions, like it is the small policy Aff from controversial Congress things like COVID and things like that. So here's the better disad. This is disad number one you need to add to your arsenal, which is deference or political questions. And this is the idea that the courts should just defer. They should not be the first to act. They should follow the lead of the other branches, the executive and the Congress, because those are elected branches. The courts are not elected branches. The good thing about this is it's easier to prove unique, because despite the fact that the court makes a lot of decisions, they usually do not they do not contradict the other political branches, the Congress and the executive, very directly, or they do so in a very constrained, easy to fix way. This is also better than legitimacy disad because Roberts' court is kind of sporadic ideologically. Even though it's not really sporadic ideologically, the cards are all over the place. Like when Roberts rules with the liberals to outdate an abortion restriction, oh, is Roberts a secret liberal? Is the Roberts court is centrist? Is it secretly progressive? Blah, blah, blah. Which makes it hard. It's like, oh, they're making popular decisions over here, but then they're doing like voting rights stuff and death penalty stuff over here that's like kind of unpopular. So like it's all over the place. They're doing all kinds of decisions everywhere. But generally they're minimalist, which means that they do not make very sweeping or expansive decisions all in one. They are very gradual. They're all very minimalist, and it's easier to find cards that substantiate that idea, that they're not rocking the boat and they're not directly confronting a lot of the political branches. An example of this is like when they just recently ruled on Trump's financial records. They did technically say Trump, it's like, no, Trump, your executive privilege arguments don't make any sense. We're not going to vote on those. But they didn't really make it so the Democrats could get the financial records in a way that was like faster or that could impact the election. So they kind of split the difference. And that's usually what they do, which is usually better for political questions or deference. They usually do the least amount possible to resolve the case. And then this is useful, has reasonable spillover impacts. You can, it's better generally to make it in the context of the topic, basically. So you would say the court should be deferential to law enforcement and law enforcement decisions. You should let the political branches manage law enforcement. And the reason, there was another reason I had, but we're going to talk about that later. It's on another slide. Other court disads, you might have heard, the progressive pressure one. This is the idea that like progressives are really mad at the court. They didn't like Kavanaugh and Gorsuch the way they got nominated. They didn't like really either of them. So they're really mad about the court. They're really focused on, oh, wow, the Supreme Court and stuff. They can really subvert democracy. Trump's getting all these appointees. McConnell's only appointing judges. He's not really doing anything else. It's bogus. The judiciary just blocks progress. These like radicals are getting life terms. So we should really focus on resolving that. And it's kind of like a movement's just said. The AF placates them. It does a liberal thing. It's like, oh, the courts are great. The courts can protect us. Blah, 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 which kind of happened. There's reasonable examples of that happening during the Obama administration, people caring about the Supreme Court like way too much. The issue with this dissad is that it's just bad, yeah. The issue with that court dissad is the similar thing, thresholds, right? Again, there's too much evidence. There's no good link evidence. This is kind of like, progressive pressure is kind of like a disjointed dissad that is made up for debate purposes, because there is evidence that there is this idea, this like placate link argument, but what the issue is it doesn't distinguish cases between cases. Like, oh yeah, if like the court does this thing on abortion, that will definitely placate them. It kind of is just in too broad a term, so there's too many things that fall under the generic umbrella of this link argument because it's kind of constructed, which means it's too hard to prove unique or have a specific link, which makes it tough. It's too easy. It's too hard to distinguish it from all the cases that the court is forced to make every year. Then every other court is that we're going to talk about these a little bit later, but they're generally kind of bad. Mostly they're subcomponents at best of other arguments. And we're going to talk about some of these in like the backfile check section. But, most every other court dissad that is backfiling in nature or super generic in nature should generally be avoided. You kind of want to have a political question deference thing that's kind of specific to the topic at hand as your first court dissad. And we're going to talk about some other offense in this maybe very next slide, potentially. Yes, impact turning precedent. This is some other good court offense. This is something that you probably maybe have not really dipped your toes in or developed your files on, but this is a great way to engage court asks, because like we said, you can say the court is bad, you can reform criminal justice, but you don't set precedents, which means you can impact turn the precedents. And what I mean by precedents, there's a lot to choose from. On this topic, the Commerce Clause, federalism, equal protection, international law. Judicial independence isn't really a precedent thing. It's just kind of like a genre of court advantages to justify them, so it comes up a lot. And then positive rights. Positive rights are like right to health, right to home, right to a job. The government is required to give you things. You're entitled to things. The way rights in the US usually work are they're negative rights, which means you are free from being intruded upon, or free, it's like negative freedom. So you're free from unnecessary search and seizure. You're free from being infringed upon, but you're not owed anything in particular. And there's some debate about which ones are better, positive or negative rights. And the AF would generally be, if they're in a kind of a more liberal progressive direction, they'd be positive rights. And the reason this precedent good stuff is reasonable, and the deference dissad in general, there are some court bad themes that you want present. And it's better generally, you can read these cards generically, but it's better to have some cards that are in the context of criminal law, criminal justice, law enforcement. The first one to make note of is that they do not have expertise. They are not experts in the field. Judges are generally generalists. They only are worried about interpreting law and like statutory interpretation. They don't have experts in the fields that those laws are about. So it's generally better to let, political branches who can get informed by experts make decisions. They also, one of the other things about expertise is the information that they base their, let me see if that's, the other one is accountability feedback. They're unelected. They do not have electoral pressures. They can't get booted out of office. So there's no real accountability or feedback. They can kind of just do whatever they want. And Congress and the executive obviously have to be honed in public opinion. They have to worry about two sides. There's audience costs. The court, they have to worry about their legitimacy, but some people debate about whether or not judges actually care about that much. And then piecemeal, patchwork, slow. That kind of means they have to base their decisions off of court cases. So facts have to be presented, cases actually have to happen. Court cases start with a limited set of facts, whatever the particular situation is that caused the lawsuit in the first place. That is what the court is ultimately evaluating. And so to develop, precedent that makes sense in a wide cross of areas, then it takes a long time. Each decision is going to be incomplete. Each decision is only going to be based on the facts. It's not going to be a holistic, comprehensive solution that like Congress through lawmaking can do. So you can see how those things would apply to criminal justice, right? Like if judges are making decisions and they don't know anything about law enforcement or investigating crimes or terrorism or how, and they're making decisions that cause uncertainty with those law officials about complying with court decisions, and things change, but they change slowly from time to time. And then, the courts are saying, hold on, you can't do that until we figure it out. Like in Kentucky, the governor just issued like mandatory masks and COVID restrictions. And then this like district judge or circuit judge, I can't remember how state courts work, but this like localer judge was like, no, unconstitutional, bad, whatever. And so there was a mask mandate for a few days, and then there wasn't for like a few days. But then the Supreme Court is like, everyone chill out, relax. The order will go into place, but we'll make our final decision. So it's that kind of uncertainty and kind of patchwork piecemeal thing that is not as good as just like if the legislator passed a law that was like everyone has to wear masks. Any questions or concerns about that? This is kind of, these themes plus like deference are a good way to get a generic court dissent. And then having some impact turns to these are another way to have a second source of offense. And then another thing I want to mention, which is the grounds pick, which is where you take your impact turn to their reason why they're making the court decision, and then you pick a new one. This is the other time where this is kind of the only time the court as an actor makes sense, because you're going to read a lot of court dissents that link to your court counterplans. So this is a case where you can kind of, it's just a pick. So you just need to debate about whether the grounds are actually necessary. And a really popular one is international law, because international law has a lot of the same principles as egalitarian view of equal protection. But what is interesting is that you can say the courts need to explicitly say international or, bigger than federal, bigger than national law is more important. This is kind of the card that says that. And there's another card, I believe, that says the same thing, which is if the court made a decision that involved both domestic law and international law, that doesn't really set a precedent or make it clear that the court is incorporating international law above national law, that it's violating that national supremacy. So international law is a very popular grounds pick for that reason. Because it kind of has all the same ideas, but you can generate a net benefit off of it. And you can interchange again. This is why doing the precedent good bad work. It creates grounds picks, and it gives you impact turns to read as well. So this is a very
I have a question about that.
Sorry?
Could I ask you a question about that?
Yeah.
How do you get competition if the AF doesn't necessarily like specify grounds in their plan text?
Tough. If it's not in the plan, I would say that you would want to if they are like an app that needs to specify some grounds, but they just haven't done it, then you want to go the other direction and try to attack them on the part like circumvention, and say that the court won't rule for that decision, and they'll come up with, like if you don't specify your grounds with a Roberts court is going to make a very minimalist, very narrow decision, and it's not going to solve your advantage as well, right? Which is why people kind of put in the plan to hedge their bets. But if they don't, because they want to mess with your counter plans, then that's how I would punish them. Not necessarily with the grounds back, though.
Wait, so does the pick just like get rid of the grounds for which they decide the case, or
It changes them.
okay?
It it just changes them from whatever they have specified to another thing, and then it would say that that particular precedent is bad. Is there a way to make a generic distinguish? We're going to talk about distinguish in a minute from the chat. It took me a second to figure out where the hell the chat was in the share screen view. Okay. Okay. All right, let's continue on here. How much time we got? Okay, we got about 20 minutes. That should be good. All right, another good court disad. The backlash disad. Here's the thing about the backlash disad. It's also called court stripping. The reason it's called court stripping is because it is the other branches saying that the courts do not have the jurisdiction to make rulings in this area. So it strips the court of jurisdiction. Here's the virtue of this argument. The virtue of this argument is because when the courts do something that the other branches don't like, they generally do get mad. Those cards are kind of easy to find. They're plentiful. They apply across a wide swath of areas. And if it's true that the backlash is substantial, then the odds that that backlash would result in something that takes out the case is very large. So there's a very built-in defensive opponent if the link is true, which is very strategic. But the sketchy part is that the impacts are poop, that the larger impact is hard to get to. Again, because what's the threshold for backlash? Courts make a lot of decisions. Some people get mad. What exactly is it about the plan that causes, the thing to boil over? In theory, if the Roberts Court was doing reasonably good stuff, you could read that as an impact and then say that's why you wouldn't want to open them up to backlash. Whether you can find cards about that is open for debate. The more general type that's always kind of just there, these are kind of one of these timeless arguments, is about judicial pay, where if the political branches get mad, they can cut the pay of the judiciary. It kind of turns into court clog a little bit. It just compromises the functioning of the judiciary. There's a built-in rule of law component that if one of the checks and balances compromises the other one, that you kind of have a messed up constitutional system. Happens a lot in other countries. So again, it's not the case that you're reading it because the external impact makes a lot of sense or it's great, but you're really making it, if you can find the really strong link cards and they take out the case, you don't need that much external offense to make it a reasonable argument to read. Court clog. The issue with court clog is it's just a good core generic on this topic. You should just be reading court clog against everything. But the link is less about the court making a decision in specifically, but mostly the fact that criminal justice reform creates litigation through backlash to it, like police unions will sue, but it also creates new litigation from defendants and people charged with crimes because they want their convictions overturned, which are two forms of lawsuits that clog the courts, which is kind of just true of any. So in this topic, court clog isn't really because the courts made an action versus Congress. Congress can create court clog as well if it does criminal justice reform. Last court DA I want to talk about is court politics. This society is usually not very good, but you got to do what you got to do sometimes. And the main issue with it is that who is the swing vote is really unclear. In the abortion case, Roberts was the swing vote. He ruled with the 4 liberals. In the Native Tribe Oklahoma case, Gorsuch was the swing vote. Actually, there was more than, I think that was, I don't know if that was a 5-4. There might have been extra votes. I think Roberts might have voted for the tribes too, but Gorsuch wrote the decision. And the reasons why Gorsuch and Roberts do their stuff are totally different from one another. I'm not sure Kavanaugh has ever sided on the other side, or Alito or Thomas, so they're obviously not very swing votey. And the reason the swing vote question matters is because that's kind of your base internal link to the scenario. And without that, your dissent's not making a lot of sense. It is the case that Roberts makes decisions politically. It's just a question of whether the plan would have anything to do with his overall calculus. And there are some timeless questions with court politics that don't necessarily get better or worse. They're just always the same. It's kind of like the normal politics of SAD, which is, a lot of your equity going for this argument is based off lack of attention to detail or forgetting how to debate the argument, not because the argument is necessarily overpowered. Obviously, it depends on the case what the impact is. I thought that there was, yeah. The main point is that the court politics disad is basically a specific form of the legitimacy disad, because it says a certain decision is going to be made now, which is a little bit more of a discrete uniqueness claim that's easier to prove. And then it says the plan affects the judge's perception of their legitimacy or their public standing or public opinion, and that causes them to change their calculus. So it's the same legitimacy link, just applied to a specific scenario. And then the impact obviously has a threshold, because if the case is decided one way and you have a card that says that triggers an impact, that's much easier than saying nebulous amounts of legitimacy cause certain kinds of impacts. So it's easier to prove that way. But you obviously have some issues with, like, why is the link so one-to-one? Why is it because the plan over here means he does this exact thing on this case when there are so many cases to choose from on how he changes his decision? And I guess that would be kind of one of the core beefs. And then there's a lot of social science about whether the court this legitimacy disad, if judges just make decisions because they do whatever they want and they don't really care, or do they take politics into account? Lots of good social science evidence that says they don't. Those would be the two big objections to the court politics disad. But let's talk a little bit about writing one. You got to look at the docket for important cases. This is tricky right now because the Supreme Court just emptied their docket, so figuring out exactly what they're going to do in the fall is a little unclear at the moment. The key thing that you have to find more than anything else, a lot of people just look at whatever, they just assume they can make any case a court politics disad. You really need to find internal link evidence, which is the decision could go either way, or what is being, and you really want the fact that you want one of the judges to be like, ooh, I don't know, how should I make this case? What you want them to have political thinking in there. You want an article that speculates on the judge's thinking on how they're going to make that decision. And then generally, you got to be pretty creative to get a good court politics disad, because the impacts are not straightforward. It's usually not a straight line to an impact. You got to be creative. And so if that's not your style, then the court politics disad is going to be kind of difficult to write. One of the big ones that's been delayed, that's kind of on the radar, is just this overturning the ACA thing. I only bring this up because it's a marquee case. I do not think that you would probably be able to find evidence that says Roberts is going to blow up the ACA after he's defended it 3 times, at least twice, maybe 3 times. This would be the 4th time. So it seems very unlikely, but that's kind of the most big marquee case that I'm aware of right now. Like I said, the term just ended, so it's not, the articles were a little unclear about what's going to happen in the future. A lot of people, the articles I found most recently were just about the 2020 election impacting the Supreme Court, which obviously doesn't help. The link uniqueness question. So here's the thing about link uniqueness, and this will help you in general, but it will also help you in the case of the court. So here's the issue. Uniqueness does not mean that the plan and only the plan triggers the DA. That's not what uniqueness means. Uniqueness means that the plan is sufficient to trigger the DA, and the DA is not occurring now. So unless the AF can explain why the plan and another case are the same thing, there hasn't really been an argument made, because you should definitely avoid framing your links as any court action in this area is bad, or any court action with a liberal leaning is bad. You should first make your argument a little more specific. It just has to be even a little bit beyond. It has to do with the courts can act, the courts do actions, but you need it to be if they take this particular action. And then, saying that the courts made a sentencing ruling is not the same as saying, well, particularly in this context, it should make pretty sense, because I do not believe the courts have been the courts just undid Florida felony voting. They just did federal death penalty stuff. I do not think that they've been very anti-mass incarceration with that thing. So it should be pretty easy, even though they're making criminal justice rulings in general. It's not really in the direction of the F. And it's just a question of how you frame your link. And then pointing out a case exists without it making a further argument doesn't really do anything. But most people think it does because they have misframed their link or they have misunderstood what uniqueness means. Then the other thing you could do that's easy to cut cards about is say that the link is small, the precedent was small, it's gradualist, whatever. The AF can't really say the same thing about themselves because they all have precedent advantage, spillover claims, things of that nature. In this case, especially even if it's a structural violence AF, to be a structural violence AF on this topic, you have to like mess with state and local prisons, which is a giant federal court overreach. So they can't really say they're small. Even if they don't read impacts, even if they don't have like a precedent spillover impact, even if they just read structural impacts and framing, I would still say it's a pretty big court F because you have to deal with like the 85% of state prisons. All right, now we're gonna talk about the other side. The court's good, CJR bad. Means topic disads. Court clog, These are the big three that you could read against courts. It forces resource trade-off, messes with federalism for the reason I just said, or court clog, which we talked about earlier. And then, this is the counterplan part that goes with it. You gotta solve the precedent without impacting criminal justice. And the way you do that is with the distinguished counterplan. And the distinguished counterplan is when the court says that a precedent that should apply to an upcoming case or a case that they're deciding right now doesn't apply because there's a key difference in the cases, even though they are pretty similar. So you would have the courts declare that that equal protection or the Commerce Clause works this way, but it doesn't work this way in the context of criminal justice, which keeps criminal justice the same, but everywhere else it's different. The reason why criminal justice is different doesn't really matter, but you should try to like do a little research and make it as plausible sounding as possible. Maybe law enforcement has to do with public safety. So the Commerce Clause means different things in the context of public safety or something. I don't know. But it doesn't really matter because you can just fiat it. The courts can say, technically the courts can just say whatever they want. So it doesn't really matter what your reason is. And that's how you solve precedent without impacting the topic. Then you read topic disads, and that's court's good, CJR bad. Yeah, it picks out of the topic area functionally is what you resulted in there. So here's what your 1 and C would look like. You got one counterplan that does CJR. You got one counterplan that does the precedent. You got maybe one of these big counterplans. You got one DA about the court. You could read more DAs, obviously, but this is the minimum, I would say. And then one DA about CJR. You got that cooking, then you're in really good shape because it's very hard for them to provide an answer that does both, to answers both parts of your strategy at the same time. Every reason the court is good could get absorbed by distinguish and vice versa. There's one other part of the debate. We can talk about this. This is just to check your files. This is a quick case checklist. Modeling internal links, international law incorporation internal links. Always read that court stripping argument on case because it takes it out and then it makes it so your crappy external impact will get scrutinized less. And then you want no solvency circumvention. And this is the idea that, like we said, that there's a lot of state and local actors. There's a lot of other lower courts. There's a lot of other things that could come up in the criminal justice context that could lead to circumvention. There's also like a totally taken over Trump judiciary can obviously kind of circumvent one liberal court ruling. You want to say that one ruling doesn't do enough and things of that nature. And then the other thing, yeah, this is one of the last things I want to talk about, which is T enact on this here topic. So the neg is going to say that enact laws means legislative bodies. The AF is going to read some cards that just say enact within court, like 20 of courts. Like these cards are just going to, a lot of these cards that I looked at say, they're like, I know this is unorthodox, but I'm going to say it anyway, that enact means judicial rulings, whatever. Neg evidence will surely be more precise. But can the neg make that an impact by itself? Like the neg having better cards does not necessarily mean that they just automatically win a T debate. Because there's a normative question, which is, does the AF need the courts, or is the AF being Congress and the neg being courts a good topic? And that's the normative debate that you have to win T and act on the neg. You obviously have to win that the AF shouldn't be the courts, and that division of ground is good. The AF is going to say, we need the courts for whatever, I guess, like solvency or circumvention reasons, or to answer the state's counterplan, I guess. And this is the outline of the debate. I'm not sure where people are going to fall on. I think people are going to be attracted to this because the neg cards, they like cards that have intent to define. They like cards that explain why a word is something and isn't something. The court cards are a bit of a reach, even though in terms of enacting reform, they certainly can achieve. If enacting reform is just changing the system, courts can obviously change the system, but changing the system obviously could open the door potentially. Maybe legislative bodies, maybe the neg can make a limits argument about why enacting reform legislatively limits the scope of potential change, which makes it easier to research. I do not know if I've seen a neg card that goes that far, but could be worth looking into. But I do not have any final things to say about that T and act debate. And I had this little, but I'm going to open this up. Does anyone have any questions as we dwindle on time here?
I had a question about the deference political thing. What was that? Is that about again? Like just not like the reasons why, but like the actual like how you run it.
Yeah, it's like the courts are following along and not invalidating or changing the course of criminal justice policy based off what Congress and the executive done. So one idea, like if the Congress passed a crime bill in like the 90s and the courts showing deference just were like, yep, this is cool, this works, this is like whatever your authority, like whatever the necessary and proper clause, commerce clause, this works, that's fine. Not showing deference would be invalidating that law. Does that make sense? And you want to say that the courts need to defer to the political branches because of those court bad things. They lack expertise, judicial change is slow and uncertain, and they don't have any accountability, so their decisions are going to be like more rogue than the political branches. And it might embolden the courts to start not deferring in other areas, which is bad. And then you read impacts about like foreign affairs or terrorism or things like that.
By like political branches, like which ones do you mean?
The president and Congress, or the executive and Congress. Political branch means they get elected in elections. Can you give an example of how impact turning a precedent would look like? Yes. So if the AF said that the Commerce Clause meant that the courts could get rid of all prisons because whatever, then you would say an expansive definition of the Commerce Clause is bad because it justifies all kinds of far-reaching federal laws, like the Endangered Species Act, which hurts businesses, or in the court's counterplan, I believe that you can see an example of this Commerce Clause disad type thing in the BK court counterplan generic, which is a further example of impact turning precedent. Or it's incorporating international law. International law is bad because the norms that they promote are problematic. Like if you think international law is a thing, that means that you will start doing humanitarian intervention to protect human rights, and that's bad. What is the difference between progressive pressure and the court legitimacy bad? Progressive pressure is like an impact to court legitimacy bad. So there's not much of a difference. It's just you can read other impacts to court legitimacy being bad besides it placates progressive pressure to court pack. But reasonable question. What else? Okay. then that is where we are going to end it. Thank you all for coming. Have fun in lab come 1 p.m. Eastern.
Thank you.